right. Good morning, everyone. This is our March Take a Stand webinar. Our panelist is Neal from the Neal Law Firm. We want to first thank Ms. Carlette for providing our CEUs. Ms. Carlette is from the Human Resource Options and Solutions. Her email is provided here, hro@humanresourceoptions.com. Some CEU housekeeping rules. All evaluations sent to www.humanresourceoptions.com. Your information submitted should be listed as what is recorded at your licensing boards. Home address and personal cell phone number, not your business address. Third, evaluations must be submitted within 24 hours after the class, no exceptions. If not submitted within the time frame, no certificate will be provided. For those who are sharing a room to view the meeting, each person does need to register for the class, complete the class evaluation, and note that in the chat box to the hostess of the meetings that they are in a group. We want all attendees to receive their CEUs. If you phone in, not Zoom, please identify your phone number that you called from to cross-reference. Anyone who has not registered and their name or phone number is not on the Zoom report, you cannot receive a certificate. First, I'd like to tell you a little bit about AAAs, or Area Agencies on Aging. The Alabama Aging Network has provided programs and services to seniors, caregivers, and individuals with disabilities for over 40 years. The Aging Network operates in all 67 Alabama counties to support individuals across the continuum of care, from the very well to the very frail in the community and long-term care facilities. M4A, or the Middle Alabama Area Agency on Aging, is one of the 13 local area agencies on aging. M4A serves Walker, Blount, St. Clair, Shelby, and Chilton counties. Each county in Alabama is represented by a AAA. The overall mission of the Aging Network is to help individuals age in place within their communities. 90% of older adults want to age at home by 2030. 1 in 5 Alabamians will be 65 or older. As baby boomers age and the proportion of the Alabama population over the age of 60 increases, there will be a corresponding increase in the need and demand for physical health, social supports to ensure a sound quality of life for millions of older adults in Alabama. The Aging and Disability Resource Center, or ADRC, serves as a single point of entry to long-term care services and support, empowers people to make informed decisions about their long-term care supports and services through. You can call 1-800-AGE-LINE to be connected to your local AAA. Some of the programs that are provided by the area agencies on aging include nutrition services, caregiver support, medication assistance, insurance counseling, senior employment, legal assistance, elder abuse prevention, and long-term care support. Lastly, I would like to advertise for our Community Fraud Summit on March 15th in Jemison, Alabama, and you can register on our website. Lastly, to receive your CEUs, please go to the Human Resource Options website, and I'll put it in the chat box below. Now I will be turning it over to Ms. Jan Neal.
Good morning, everyone. We're going to talk about wills and trusts in Alabama. I had this presentation earlier, and this has been expanded a good bit and brought up to date. This is a topic that we get an awful lot of questions about, and we deal with a lot of wills and trusts. This is my contact information, and I don't want you to be concerned, because at the end of this, I'm going to show you how you can access this presentation. and actually download it. You'll have the information. And I know that keeps you from having to take a lot of notes and things like that. But this is how you can contact us. And I've given you our website, our Facebook page, our Twitter feed, and our LinkedIn page. The question I always get is, do I need a will or do I need a trust? And I will say one size doesn't fit all. Like what will work for one person isn't a good choice for another. This is really something that in order to identify, you need to ask yourself some questions about what it is that you're trying to accomplish. Those questions include things like, do you want to save money and time for yourself? Or are you more concerned about saving money and time for your heirs? If you're more concerned about saving money and time for yourself, you'd be more likely to pick a will. If you really want to save money and time for your heirs, you're probably going to pick a trust. How willing are you to do the legwork to fund a trust and keep it up to date over your lifetime? If you're not willing to do that kind of thing, don't get anywhere near a trust. But if you are willing to do that, then that might be a good option for you. You look at what property do you own and where is it located? Is it in just one state or is it across multiple states? Is it mortgaged or is it debt-free? I will say that one of the best reasons to have a living trust is in order to avoid the problems you can have probating a will in your state and then having to carry it off to another state to get the property you own in another state transferred. So a living trust is a real good option for people who own property in multiple states. You have to ask what the value of an estate is, because if you have, yes, that is correct, $25.84 million if you're married at death, or $12.92 million if you're single this year, then there are estate tax considerations, and you might need something more than just a revocable trust or just a will. You need to ask yourself if you're concerned about providing for disabled relatives, because you can do that sort of thing through trusts. And how important is privacy in passing your estate? You have more privacy with a trust than you do with a will, though I wouldn't say that a lot of information about you or your business is revealed through a will. It actually can be, but it doesn't have to be. But I would say that a trust is more private, definitely, because it's not of record somewhere like a will is. Let's first look at what property is included or is controlled by a will. Assets that are titled to the deceased person alone, that would be something that goes through a will. Assets that the decedent owned as tenants in common with someone else, but it is not joint tenants with right of survivorship, their partial interest in that property will go through their estate. Assets where with the estate designated as the beneficiary or with no beneficiary named and not payable on death to someone else. An example of that is you have a will, you have a bank account and you have nobody that owns it with you. You didn't name it as a payable on death account. That's going to flow through your estate. Money that's owed to the decedent that'll be paid after death will go through the estate. That would be lawsuit proceeds, the last paycheck, refunded deposits, things of that sort. Non-probate property, in other words, not controlled by a will, includes property that has a beneficiary designation. Insurance is made payable to someone that's not part of the probate estate. Payable on death accounts. You can now open a lot of bank accounts where you can designate where the funds go at your death. If you do that, those accounts would not be included in your will. IRAs, you have a beneficiary on those, investment accounts, and transfer on death securities. So you can see that there's an awful lot that doesn't have to go through your will, though some people may choose for some of these things to go through their will. Property and accounts with a joint owner. The joint owner is going to take it all. So it included in your estate. Real property that's titled to multiple owners as joint tenants with right of survivorship is not included in your estate as probate property. In other words, if it says specifically in the deed that John and Mary own this property as joint tenants with right of survivorship, that means if John dies, Mary owns it automatically. And if Mary dies, John owns it automatically without you having to do anything. You see married couples who title their property like this often. Property that's held in a life estate where the decedent's interest in that is the life estate. In other words, let's say Mary gave her property by deed to her children, and she retained a life estate. That's all she owns is a life estate. At the moment of her death, the life estate ends and her children automatically own the property. Now, the first thing to realize is that if you don't probate the will, it doesn't have any authority. And now that seems pretty simple, but you would be surprised at how many people I run into. I met with a woman just the other day who wanted to transfer her property to a grandson. She and her husband owned it, did not bring her deed in. And I said, I got to see the deed first. Did you probate your husband's will, administer his estate? And she said, no, I didn't, but there's a will and he left everything to me. Well, how long ago did he die? About 8 years ago. The will's too old. It has to be accepted by the probate court within 5 years of death. Well, I hate to say it, but by the time she brought her deed in, I found out that they did not own it as joint tenants with right of survivorship. And that means that part of the land she wants to transfer is still in her husband's estate. I think this is going to work out because by operation of law, his share probably went to her because it was pretty low value. And that's because of Alabama's intestate succession law. That's the law that says where your property goes if you do not have a will and you administer an estate. And you hear the term heir property all the time. That's because property automatically passes if you don't have a will. To have clean title, you want to administer the estate. But even if you don't, here's how property passes. If there are no children and no parents, then it all goes to the spouse. If there are no children, but there's a spouse and there are parents of the deceased person, the first $100,000 plus 1/2 of the balance over $100,000 goes to the spouse, and 1/2 of the balance over $100,000 goes to the parent or parents of the deceased person. If there is a spouse and a child or children by a previous relationship, 1/2 goes to the spouse and 1/2 to the children or child or children of the previous relationship. Now, this is kind of shocking, and I often see people's mouths drop when they hear this, because the children of the current marriage don't receive anything. They have to wait for their parent to die. So let's say somebody got married long, long ago and they had a child, and that child and them had no contact for years. The person remarried and stayed married 50 years and had 3 children. Well, 1/2 of whatever's in the probate estate would go to the child by the previous marriage and 1/2 to the current spouse. That's kind of shocking. If there are children and a child or children by the surviving spouse, let's say there wasn't that child by a previous relationship, and you see this often, the first $50,000 goes to the spouse plus 1/2 of the balance over $50,000 to the spouse, and 1/2 of the balance over $50,000 to the child or children by the surviving spouse. So in that scenario, I was telling you about the woman who waited too long to probate her husband's will. His share of the property was lower than $50,000. And so I'm assuming that would automatically pass to her by law. Now, if there's no surviving spouse, then the distribution goes like this: all to the children or the child, all to the parent or parents, all to the siblings, grandparents, aunts and uncles, and cousins. That's the way it goes. Now I see let me see if there are questions in the chat box. Nope. Okay. Now, do realize that not all wills need to be probated. There are states where a person signed a will, but it doesn't need to be probated. This happens sometimes when you have spouses who jointly own all their assets and they own their property as joint tenants with right of survivorship. If all someone has is an automobile, then it can be transferred by an affidavit. And I swear to you, this is the title of the affidavit. You can get it at the probate court. Affidavit for assignment of title for a vehicle from a deceased owner whose estate does not require probate. That's the Alabama Department of Revenue MVT 5-6. If the car's paid off, then and there's no lender that you have to deal with, then the title can be transferred by filing that affidavit at the tag and title office of the probate court. But it does have to be the next of kin that files that. And you do have to swear that there's no estate that requires probate. So you have to look at what property needs to be transferred to decide if a will needs to be probated or not. It's really important to get legal advice, because after 5 years, the will cannot be probated. And with administration of an estate, where property passes by intestacy, there may be unanticipated consequences. I'll give you an example. I represented a woman and her daughter, and she came in to have her will probated, and she and her husband owned with some other people part of a local business. The husband had died about 12 years ago. His will said that the wife would get everything that was his. Well, the problem was he had a wife and he had a child and he had a son who had died many years ago. The son had a daughter. So by operation of law, his interest in that business was going to pass to his wife, and then ultimately to the daughter. She was going to get a share of it because it was over $50,000. And then the granddaughter was going to get a small share of this business. I don't have to tell you that that was not what he anticipated. That wasn't what he wanted. That wasn't what his wife wanted, but that's what ended up happening. And it turned into quite a mess. Let's see. Okay. Wills do require court intervention. You name a personal representative, and you might be more familiar with the term executor. That was the term for years and years, but when the probate code was updated, the person in charge of your will is now known as the personal representative. The court accepts the will and appoints the personal representative to handle the estate of the person who made the will, and that's the testator. You can name somebody who lives out of Alabama to be the personal representative in a will. But if you die without a will and your estate has to be administered, the administrator must be an Alabama resident. I've begun running into problems with this. You have all the kids scattered all over the country. One parent left in Alabama, they die. Who's going to be the administrator? They didn't have a will. Who's going to be the administrator? It does have to be an Alabama resident. If you die with property that needs to be transferred, your heirs will have to hire an attorney, and the court process is required. And the property can't be transferred until 6 months pass to give potential creditors time to file claims against the estate. I'm going to stop there for just a second and see if any of you have any questions, anything. I don't want to ignore you. Okay, moving on. The steps in the probate process, generally speaking, they're a little unique depending on the estate, but generally you file a petition with the probate court. You send notice to the heirs under the will and to statutory heirs. That's your next of kin. They have to be notified. That's why we had that granddaughter being involved in the case I was telling you about, because your next of kin is your spouse, your children. And if one of your children have died, it's their children. You file a petition to appoint a personal representative in the case of a will, or an administrator of the estate if there was no will. You do an inventory and appraisal of the estate assets by the personal representative if it isn't waived. Most wills waive that accounting and inventory, but if you're administering a estate, it has to be done because there was no will to waive it. You have to post a bond by the administrator if there was no will, because a will usually waive the bond, but when you have administration of an estate, there's nothing that waives it. You place the assets in an estate account. You have to get an EIN, tax identification number for the estate, because it's a separate entity. You send notices to known creditors and you advertise in the paper for unknown creditors. You have to send a notice to the Alabama Medicaid agency in every single estate in Alabama that's opened. You all may have heard me talk about Medicaid estate recovery. This was one of the requirements. And it's kind of shocking because young people die that never got Medicaid, rich people die that never got Medicaid. And despite that, Medicaid has to be notified, check their records, and make sure that person doesn't owe anything to the agency. You have to pay the estate debts to rightful creditors after 6 months. You may have to sell assets. You can have in a will, like I leave my house to my 2 children in equal shares, and then you would be doing a deed to transfer the house. But if your will says, I want my house sold and the proceeds divided, then the personal representative would be selling the asset and then dividing the cash. You pay any estate taxes if applicable, and then you have the final distribution of assets to the heirs. If one of the beneficiaries is a minor or an incompetent person, then law requires that a guardian ad litem be appointed to represent that person. And that would be anyone who suffers from incapacity, they couldn't understand and sign papers for themselves to waive any dispute that they might have against the probate. And it's anyone under the age of 19, because 19 is the legal age in Alabama. The guardian ad litem is an attorney who is appointed to represent the person or the minor, and the estate will be required to pay the fee for the guardian ad litem. I'm guesstimating that I usually see those between $400 and $500 where I live. I guess it could be different depending on what jurisdiction you're in. And this was an interesting thing I just learned the other day. I am representing a woman who is probating her mother's will. And the mother had about 6 different children. All of the kids can sign waivers and say, hey, I'm happy for her to be the personal representative. I'm not disputing anything. But one of her sisters is of advanced years, and she had a stroke, and she can't really understand things so much. I talked to her, and she's sort of there, and then she's kind of not there. But she did have a power of attorney, and she had named another one of the sisters that she lives with to be in charge of everything for her. And one of the things in the power of attorney is that that sister can handle any court proceedings, any estate issues, anything of that nature. So I thought that ought to suffice the sister to sign for her, but my local probate judge in Lee County said, no, we're going to have hearing. So there will be a hearing on that in a couple of weeks, and a guardian ad litem will be appointed to represent the incapacitated sister. Now, just a word about titling assets and beneficiary designations, and this might be a little repetitive, but it is good to have this firmly in your head. Even if an item is listed in for a particular beneficiary in a will, the gift will be overridden if there is a designated beneficiary on that account. So you leave Mary $500 in your will, but there isn't any money coming into the will. You have an account that's got $2,000 in it, and John is the beneficiary on it. John gets all that money and Mary doesn't get anything, even though it was written into the will. If property is listed in a will, the deed will override the will if the property is titled as joint tenants with right of survivorship. So that's why in wills where the attorney has seen the deed and knows that it's titled as joint tenants with right of survivorship, you'll see where the will says, if my spouse dies before me, then I leave this property to so-and-so. Because if it's joint tenants with right of survivorship, the first to die, the other's going to own it entirely. And if an account is jointly owned, the co-owner is going to take all the property in that account without probate. And if a person wants the property in a particular account pass through a will, he has to designate his estate as the beneficiary, or have no beneficiary designated at all, nobody payable on death. So you can actually set up an account. Say you want every grandchild to get $1,000 and you have 5 grandchildren. You can put $5,000 in a bank account and make the beneficiary of that account your estate, or have nobody own it as joint owner and have nobody payable on death, and it's going to flow into your will. And that's how you get the cash to give to specific persons. I very often hear people say, oh, I want to leave X dollars to every one of my children and each of my grandchildren, but there's nothing flowing into the will. So you have to make that happen if that's what you want to do. I want you to be aware of the fact that there's no such thing as a transfer on death deed in Alabama. Not long ago on Facebook, there was this get your documents in order post that just went round and round and round and kept being circulated. And it kept saying, do a transfer on death deed. Well, if you live in some other states, you can do transfer on death deed, but that isn't something that's allowed in Alabama. The closest thing to a transfer on death deed is to transfer it to somebody and keep a life estate, but that's different from a transfer on death deed. And a lot of times people don't want to do that, because if you do have a life estate in property, and then you've got the remainder people who are going to take it at the time you die, and then you want to sell it or get a mortgage on it or anything like that, the remainder interest people have to agree to that. So a lot of people don't want to let go of control over their real estate. It is important to review how accounts are titled and the beneficiary designations when you're going to do a will or trust, so that you know how to route property. Here are some common mistakes that you see. Failure to recognize debt to include Medicaid estate recovery. This can result in an insolvent estate. Somebody can owe like $100,000 on their house, but they've got all this, maybe $80,000 that they're routing into their will. And they're going to have an insolvent estate, because whatever debt you have has to be satisfied before anything can transfer to your heirs. Another problem is failure to coordinate probate and non-probate property. Like somebody might leave a lot of bank accounts to one child, but yet they wanted all their children to share in everything equally. So you've got to kind of coordinate what's going to go through the will and what's not going to go through the will and who's going to get what. We talked about failure to determine where cash will come from for a bequest, and then failure to timely probate the will. We've talked about that. Failure to make a list of real property to provide a roadmap for your heirs. When I do a will, I want to see a deed to each one of the pieces of property, and I want to put in the will who you leave it to, this property that's recorded in the probate court of Montgomery County and book so-and-so, page so-and-so. That makes it easy for the heirs to know what you own. And that's another reason to keep your eye on your will and make sure that if you buy more property, you might need to update your will. Failure to recognize that a power of attorney has no authority to conduct business when a principal dies. We had this happen just yesterday. A mother and father, I had done a power of attorney for their son. He died. They have some things they need to do, and they wanted to come in and get a copy of the power of attorney that I did because they couldn't find the original. And so they came in and got it, even though, you know, we've let them know your power of attorney doesn't really have any authority to handle anything for your son's estate. And then failure to recognize that all wills need to be, that not all wills need to be probated, and to review all the property before making that determination. I have seen people probating wills, and I can't even understand why the will is being probated, because I can't figure out what they're trying to pass. So I have seen that happen. And then, of course, we have the other ways that we've talked about to pass property through the MVT 5-6, the joint tenancy with right of survivorship, and the automatic transfer by life estate deed. I want you to be aware when you see per stirpes and per capita, what that means. When you give, you don't even see per stirpes much in wills anymore, because that's the preferred way. If you say, I leave all my property to my children, Susan and George, then if Susan dies, the property is going to pass per stirpes, which means to her children. That's a lineal descent. Per capita, if you want it to be per capita, you have to say, I leave everything to my children, Susan and George, per capita. That means that if Susan dies, George gets it all. So if you don't see anything, it's per stirpes. But if you don't want it to go to the descendants of the deceased child, you need to put in there per capita. You'll often see in a will a Uniform Transfer to Minors Act clause that says if anybody receives anything under that will, let's say Susan's children are young, you can have a custodian that takes the property for them until they reach the age of majority or age of 21, however you want to do that. You can also create in a will a testamentary trust where you name, and usually you want to do this if you have a large inheritance, and you want to name somebody to manage money for children or for a disabled person. You need to make specific omissions. I don't believe you have to say, I give my horrible child who beat me up $1. You don't have to do that. But you do need to say, it is my specific intent to make no provision for my horrible child who beat me up in this, my last will and testament. I say make those omissions, because if you don't omit your next of kin, you're opening the door to them coming in and arguing, you didn't know what you were doing. She forgot she had children. She wasn't competent, blah, blah, blah. On and on it goes. So it's better to just take your next of kin if you don't want to leave them anything and say, some people will say, I make no provision for my child, Paul, because I have made provisions outside this will. And that might be somebody who gave some land to Paul years ago and felt like his share of the estate was already passed. Another issue is finding the next of kin. That can be difficult. We have a case right now where a man had a child and she's in Russia. I'll double dog dare you to send notice to Russia right now. It's like all the major carriers aren't handling that. But we have to connect with this person, and we can't just do it by email. You know, in probate court, you have to get people's signatures on things, and it's what they call a wet signature. In other words, an original signature. Another concept is rest, residue, and remainder. in a will and when you pass property in a trust, if there's anything you didn't specifically name, it will go through the rest, residue, and remainder. And you might leave specific things to one person, other things to another. And then you go, anything else that I didn't say will go to, and you name who that goes to. When you're going to prepare a will, or I really should say trust as well, you need to know all the next of kin information, all assets, bring deeds to all property, consider who you want the beneficiaries to be and who's the alternate if something should happen to them, who's the personal representative and who's the alternate if something should happen to that person. If you have children, who do you want to be the guardians for those children? And who do you want to be the trustees for a testamentary trust to manage the money for children? Whether the personal representative should sell property during probate or just pass the property to whoever they're leaving that real estate to. Any next of kin you want to admit, and whether to include a no contest clause. A no contest clause basically says that if anybody tries to contest this will, the property will pass as though they didn't exist. That's in effect, they can't contest the will. I will say though, no matter what you do, somebody will always try, and then you have to fight them. Now, all trusts fall into two categories. There's a living trust or a testamentary trust. We just talked a minute ago about a testamentary trust. That's where one is created in a will. And a living trust is created during the lifetime of the person making the trust. That's the grantor. They're sometimes called the settlor or the trustor. And all trusts are either revocable or irrevocable. A revocable trust can be amended or eliminated at any time during the life of the grantor. But do realize that a revocable trust becomes irrevocable after the death of the grantor. So a testamentary trust is going to be irrevocable once the person who made the will dies. And an irrevocable living trust is going to be revocable as long as they're alive, but when they die, it becomes irrevocable. Again, the grantor, settlor, or trustor is the one who creates and funds the trust. The trustee is the person who manages trust property, and the beneficiaries are the people who benefit from the trust. The most common mistake I see with trusts is failure to fund it properly. It only controls the property that is titled to the trust. And so you have to be vigilant to keep your schedule of property that's held by the trust up to date. You can title just about anything you want to the trust. Some people put some property in the trust, but not everything. If your primary goal is to avoid probate, you don't want to leave any probate assets so that you end up having to probate a will and administer the trust. I will say that usually when we do a living trust, we do what is called a pour over will to catch anything that you forgot to title to the trust so that it goes on into the trust. And that keeps you where everything's accounted for, but you're not able to avoid probate that way. Now, this is an issue I don't think comes up very often, but since a trust controls the property that's in the trust, you have to be sure with your health care to look at how the trust plays with the power of attorney. And I'll give you an example. If you want John to handle your finances and health care, do not title your long-term care insurance to the trust, because Mary's the trustee, your alternate trustee who takes over when you become unable to handle the trust. And because Mary will handle the insurance claims, then that would sort of circumvent what you wanted John to do. But if your long-term care insurance was outside the trust, then John could handle the claims for the long-term care insurance. Now, if John is your financial and healthcare agent under a power of attorney, but all your money is in the trust, it could work if John and Mary can work together. But if they can't, John will be making arrangements for your care and end up fighting with Mary over how to pay for that care. Because remember, Mary's going to have control as the alternate trustee over all the funds. It would make more sense to have the same person named in both documents. And, you know, you can put all of these instructions in a trust, but I think you still want a power of attorney, because you don't want to have to bring a lengthy document to a healthcare setting. And when you're doing simple things, you don't want this whole trust to have to be evaluated by the healthcare provider. You still want very clear instructions on who makes healthcare decisions for you. Now, I do want to just make you aware of some trusts that are used for disability planning. We're going to talk just a little more about the revocable living trust. It is, and I do want you to realize that it is not a disability planning tool. I put it here because I just want to distinguish that while you can have a revocable living trust and it can do some wonderful things for you, it will, assets in that trust will not be avoidable from spend down required by Medicaid, as opposed to a Medicaid Asset Protection Trust, also known as an MAPT. A Medicaid Asset Protection Trust is a complicated document where you transfer all of your assets that you want to protect into this trust, and you name someone else to be the trustee. And the trust is irrevocable. You can't do away with it. You can't amend it. You can only have assets like income that is routed to you, and that will count as a Medicaid stream of income. It increases your income. But that if you can get your property into the Medicaid Asset Protection Trust 5 years before you apply for Medicaid, then nothing in that trust will count as an asset. But the trust has to be very, very clear that you cannot require a distribution of any of your assets from that trust under any circumstances. The only thing that you can get out of that trust is income. And, you know, that's very much like just giving away your property and then waiting 5 years to apply for Medicaid. The gifts won't count. But the safeguard here is that you've got this property designated in a trust to where you want it to go when you die. So I can see that there's a lot of advantages to a Medicaid Asset Protection Trust. It's just you have to understand the limitations. Now, when I start talking to people about Medicaid Asset Protection Trust, there are some people that like the idea. And there are other people that just cringe at the idea of losing control, complete control over their assets. They might as well be being asked to give it completely away. In many ways, that's kind of what they're doing. Now, the Medicaid Qualifying Income Trust, you've probably run into that. This is a trust for people whose income is over $2,742, the Medicaid income limit in 2023. The Medicaid Qualifying Income Trust is a document where you set it up and you go to a bank and you open a bank account named for the trust and you route a person's income into that trust to be used as the person's personal liability that they pay to the nursing home, all but their $30 personal needs allowance or any amount of money they're allowed to send home to their spouse at home. But it's a long way around the block to get next door is what it amounts to. It's a way to make it so the fact that you have income over $2,742 doesn't keep you from qualifying for Medicaid. Right now, Medicaid has as part of their application packet. You can get a qualifying trust. The biggest problem is finding a bank that understands it. We have one around here. They're probably different in different areas, but I run into a lot of problems where people go to a bank to set the bank account up, and different banks don't understand what the Medicaid qualifying income trust is. Once they do understand it, they understand you're not asking to set up a trust with the bank. You're just opening a checking account, and then you're naming it for the Medicaid qualifying income trust, which might be the Smith QIT or something like that, whatever it's been named. Now, the Special Needs Trust is wonderful for disability planning. There are a number of circumstances where you can take money and put it into a special needs trust that will pay for things Medicaid won't pay for. But Medicaid does have a lien against the funds in that account. So let's say you have, this is just an example, and there are so many different types of special needs trusts. This is why you would need to get legal advice if you were looking to set one up for someone. But a special needs trust, let's say a married couple, one of them is going into a nursing home and they have to spend down $100,000 for, say, the husband going in the nursing home, and the spouse at home can keep $100,000. Well, instead of spending that money down on nursing home charges, they can set it in, put it into a special needs trust. I would recommend going to the Alabama Family Trust, creating a pool trust, and then qualifying for Medicaid. $100,000 is sitting over here to be used for things like sitters. It can be used to pay for the private room in a nursing home, because Medicaid will only pay for a semi-private room. It can be used to pay for medical equipment or services that Medicaid wouldn't pay for. And if the person dies shortly after going in the nursing home, you have alternate beneficiaries who can get that money after the Medicaid lien is satisfied. So if you went in the nursing home for, let's say, 2 months and died, and Medicaid had only paid like $3,000 for each month, then that'd be $6,000 out of the $100,000 that would go back to paying Medicaid back. But that'd leave a lot of money, $94,000, that could still be distributed to the alternate beneficiaries. A lot of times you see special needs trust used when a person who's disabled of any age is going to receive personal injury proceeds. They're perhaps on SSI and Medicaid, and rather than have them fall off of SSI and Medicaid, the proceeds can be paid directly into the special needs trust. I do want to warn you that a person on SSI, there are more limited ways that you can use that money. You can't use it for housing and food and utilities. So you have to be very careful to understand what the money in a special needs trust can be used for and what it cannot be used for. Because if you use the money improperly, then all that money comes in and counts as an asset for Medicaid or SSI. One of the reasons that I strongly recommend going through the Alabama Family Trust is because they're not going to let you use money. That is a nonprofit entity in Alabama that is not going to let you use the money for things that you shouldn't use it for. But I see people set up private special needs trusts, and it just, I kind of hold my breath on, oh my gosh, what are they going to use the money for? Because use it wrong and it can knock someone off of benefits. Now, the revocable living trust is the will alternative. And in this situation, the grantor makes and funds the trust and names himself as the trustee for as long as he's living and competent to manage the trust property. So he retains control over all the property, and the trust is taxed in his Social Security number. So it's not really a taxable event. You're just taking what you own and you're putting it over here in a trust your trust named for you, and it's not a separate legal entity from the grantor. And then the grantor names an alternate trustee to take over if he becomes incompetent to administer the trust and when he should die. The grantor designates to whom the property passes at death, and when the grantor dies, the trust becomes irrevocable, and his alternate trustee takes over and administers the trust. At that point, the trust has to get an employer identification number. So it's important to recognize the distinction of when the grantor is alive and when the grantor is deceased. Now, in these trusts, you can make it pretty simple how you want your property to pass at death, or you can make it extremely complex. You have a whole lot of control in one of these. If you really want to retain control and tell your heirs exactly what to do, in what order, when, where, and how, you can do that in a trust. Most people don't do that, but some people are very concerned about that, and they really do want to control how all that is handled. Now, it's important, again, let me reiterate that if you put your property into a revocable living trust, all the assets in that trust will count as assets for Medicaid purposes. It won't get around Medicaid. So that's important to know. I dealt with a couple of daughters a few months back whose mother and daddy created a revocable living trust. Oh my Lord, I bet it was probably 12, 15 years ago. And they were convinced that the assets in there weren't going to count for Medicaid purposes now that the father's deceased and the mother's going into a nursing home. But they do count. And the people who set that trust up, the parents, never understood that important distinction. And I just hate to see that when that happens to somebody, because everything they planned on isn't working for how they wanted it to work. In a nutshell, wills pros, they're generally less expensive to prepare. There's no administrative work to keep it up to date. But again, I think it's really important that you review it every few years. I see wills that were written 20 years ago. Oh my goodness. And, you know, they don't even own the property that was listed in that will, or some of the beneficiaries have died. I try to write a will so that it lasts a long time. That's why I like alternates. But there's only so far that a will can carry without you needing to rewrite it. A will may or it may not need to be probated. Again, that can be a pro. A con is an original will needs to be located. If beneficiary designation or joint ownership is not in place, then accounts are frozen until the court appoints a personal representative. If a will needs to be probated, then you have to hire an attorney and have the will accepted by the probate court. And the probate process takes 6 months to give creditors time to file claims in court. So those are the cons. Trust pros, you avoid attorney and court participation with some exception. You may need an attorney to help with the administration of that trust after the grantor dies. You have increased privacy, and you avoid that ancillary probate business if you own property out of state. If you own property in Tennessee, you die in Alabama, you own property in Alabama, you probate your will, you get the property transferred in Alabama, but an Alabama court cannot transfer Tennessee property. So you have to do an ancillary probate, take that will into Tennessee and get the Tennessee property transferred. You can avoid all that with a living trust. In it, you just have to have all the property titled to that trust so that the alternate trustee who takes over at your death can do quitclaim deeds, giving that property to the persons that you designated it should go to. Trust cons. It's useless if it isn't properly funded. And you'd be surprised at the number of trusts I see where somebody never funded it. Generally, they're more expensive to prepare and they require more administrative work to keep them up to date, to create them and keep them up to date. And they don't shield assets from Medicaid. And it doesn't shield assets from creditors because creditors have to be satisfied under Alabama law before you pass property in a trust. I want to caution you about using online estate planning services. The problem is you don't know what you don't know, and you never know if something you're getting from somebody that has a website is whether it'll work in your jurisdiction. I can't tell you how many wills I've seen that fail to waive bond and inventory because the service didn't do that. Failure to explain how to identify, integrate, and balance probate and non-probate property. You may think you have everything so well handled, but you don't. Failure to consider planning for disabled children or grandchildren or spouses. Failure to explain how to fund the trust. Failure to take debt of the estate into consideration to include Medicaid estate recovery. Failure to explain next of kin to omit from a will if distribution is to someone else. Potential signing and self-proving affidavit issues. A will is self-proving if it has a particular affidavit that's exact words are used in Alabama. I ran into a will just about 2 weeks ago where I don't know where they got this will, but it was nowhere in the ballpark of self-proving. And that meant that we had to find those witnesses and do an additional step of bringing them into court to prove, or one of them into court to prove the will. The will has to have 2 witnesses, and you have to have one living that you can bring into court to prove the will if it isn't self-proving will. So be careful about that. Failure to properly pass burial plots. I see that with these online. Alabama has a quirk. Your burial plots will not pass through your rest, residue, and remainder. You have to specifically pass them in a will, or they're just going to go to your next of kin. That's just the way. That's a strange quirk of Alabama law. Failure to include provisions for institutionalized spouse. When you have a spouse who's institutionalized, there is a certain amount of money from the estate that Medicaid's going to require whoever's in charge of that institutionalized person's money. They're going to require them to make a claim against the estate of their spouse. And so sometimes you'll provide a will and you'll say, because my spouse is in a nursing home, I want to go on and designate the amount of money that Medicaid would require that they get from my estate, so that there's no problem with them falling off Medicaid or having to fight to get that amount of money. So I don't think you're going to run into those kind of things when you go to online estate planning services. I just want to warn you, some people love those kind of services, but I think that it's a little bit dangerous to use them. This presentation is going to be made available at our SlideShare account, at our Facebook page, and at our website. And our website is www.janneallaw.com. Don't get this mixed up with an earlier. This is an expanded version of an earlier presentation that's been posted. The difference you can see is it says February 2023.